Okay, thank you everyone for coming for this CLE on mediations. We all, a few minutes ago, kind of got to hear why everyone's here, a little bit about their practice. Before we get started, I guess we were just going to introduce ourselves. My name's Bruce Bagelman. I'm co-chair of the civil litigation section this year for the Boulder County Bar Association. I'm a trial lawyer. I do primarily civil litigation in a wide variety of cases, plaintiff side, defense side. I handle appeals. I've tried cases in state court, federal court. I've recently tried an adversary proceeding in bankruptcy court. So kind of my perspective. Recently in Colorado, I've been doing a lot of construction defect litigation. I've practiced most of my career in Texas and moved to Colorado about 3.5 years ago. I started my own law firm as of January 1st of this year, again handling litigation of all types and some general business transactional work. So I kind of bring more of the civil litigation, commercial litigation perspective to this panel this evening.
Thanks, Bruce. Hi, everybody. I'm Steve Clymer, and I'm, what do I call myself, the founding mediator of Accord ADR Group, which is a small group that does mediation and dispute resolution. We had 3 members until very recently, where Rob Gunning got elevated, I suppose is the right term, to be a district court judge, and so that leaves Doug McQuiston and myself. And we're doing a wide variety of cases in mediation, focusing, it seems like most of the cases tend to be personal injury, business, commercial litigation, construction disputes, and construction defect cases, HOA disputes, all sorts of civil litigation. It's not currently any domestic relation cases. And so, let's see, I've been doing, a lawyer 40 years this year, and started mediating 39 years? No, that can't be right. 29 years ago. Part-time at first doing law and mediation. Started that in '94, and it's been full-time for almost 25 years, I guess. So that's me.
Okay. Hi, I'm Debbie Taussig. I have a practice here in town, Debbie Taussig Law. We do plaintiff's personal injury, so most of what we do are car crash cases. My associate Joanna Merrill is here also. And yeah, I've been practicing a little over 20 years, and I've only done plaintiff's civil. Did some med mal back in the beginning, and our practice seems to go through lulls, like where we hardly have any cases in litigation, and now all of a sudden, we've got a number of them. So the same with that, we have ebbs and flows of how many mediations we've had, but that's it. So thanks.
So we have a number of different topics we're going to cover and questions. We're a small group here tonight, so we want to make it interactive. So if anytime someone has a question or their own perspective or comments on any of the questions that we have or topics, you can chime in, or you can hold the questions to the end. But one of the, if you saw from the emails that went out, one of the topics is in-person versus Zoom mediations now that we're kind of seem to be getting past COVID. So kind of the first question I want to pose to both Steve and Debbie, and then I'll answer that question, is whether or not you have a preference for Zoom or in-person mediations now that we're kind of have the ability to transition to both, and why do you have the preference that you have for one or the other? I guess I'll start with you, Steve.
Sure. I'm a fan. My preference is virtual Zoom mediations. And the reasons for it is I think they're very effective. They're certainly efficient. I think that I get, the main thing I like about it is I get much better participation of the parties representatives. On the insurance side of things, I see adjusters, claim reps. Sometimes we can get managers in who ordinarily may not even be in the mediation. They certainly, in many cases, wouldn't be physically there even if we were doing them in person. And so instead of, in the defense room, I've got a lawyer with, who sometimes gets an adjuster on the phone. I've got that person there and available. And when I was doing them in person, it was sometimes and disappointingly rare when they would be there. And if it was someone coming in who had to travel for the case, that was one thing. But I'm getting them there in the personal injury cases, which I really like. In the construction disputes, oftentimes they're multi-party, and I can get not only the different participations on the defense side from the claims reps, and then I love it when insurance coverage counsel shows up as well. Sorry. But that's one of the realities. But I'm able to speak with those people about those issues and to change people in and out of rooms as appropriate for what's appropriate to talk about certain folks with. On the other side of the construction cases, I get better participation as well because I've got the owner of the company, perhaps people who were boots on the ground at the time, who can all chime in, who wouldn't have dedicated a whole day to be somewhere in person as they can come in and out. So I like the participation most of all, but I really appreciate the efficiency and the convenience. And I've really noticed and tried to keep track, and I can tell everybody from my experience, I've not seen any results be different because of it being in Zoom. I look back and say, is there any case that didn't settle? Obviously not every case is going to settle at mediation. Is there any case that didn't settle because it didn't have people in person? The answer in my experience is no. So I'll stop for a while.
Okay. Yeah, I have actually now come to prefer Zoom. I think there was a period of time where I didn't, and I think it was just a mindset issue coming out of COVID and the isolation and getting tired of Zoom. I think for the same reasons Steve said, I mean, for us, in past mediations, it's been frustrating when you go to mediation, and do all this work to get prepared and then find out that it's only the defense attorney in the other room and that they may or may not be able to get the person with more authority on the phone. And so, like what Steve just said, it seems a little easier now. It saves a lot of time and money. And recently we had a mediation with a client who we thought presented pretty poorly. And, you always want the mediator's feedback. And he was able to see that, and I mean, that's not my ideal situation ever. But it seems like mediators can kind of gauge what our client is like, which is important, and give feedback to the client and us. We were talking the other day, the only thing I question is can a mediator or even, get in a injured person, get a full feel of how that person is going to present at trial? Because sometimes you have someone that says, but this happened in our last client who said, her whole life was ruined, but she presents pretty well, she's smart, and the mediator was able to see that, not the ideal client, but those things happen. And sometimes, a lot of times we want mediations for the mediator to put pressure on the insurance company, but every once in a while I want a mediator to put pressure on my client and have from an objective third party to tell my client that they need to resolve this case. So, and it's been effective. Like last time we had a mediation, we were able, I guess you can do this anywhere, but you can get other people on the phone. Like we got the doctor on the phone because the insurance company had all these questions. I think you could easily do that from a mediation room, in downtown Denver, but it just seemed a little bit easier to grab what we need and just have everything there and not be hauling a bunch of notebooks or things to court. But everything's changing. Everything's in the clouds and now everything's virtual. So I think it's just getting our mindset around it a little bit.
I'm probably the outlier because I like both, and actually I've mediated in person post-COVID, and like everyone, I've handled several mediations via Zoom. I got to say, I think still my preference, this somewhat depends on the case, which we're going to talk about later, is doing it in person, because I still like that interpersonal, relationships, be able to sit in the room with the mediator, talking about the issues. I know you can do the same on Zoom, but sometimes I just feel like you can just get into a deeper, build a better connection just sitting there. Also the same as if you end up having during the mediation, if the mediator thinks it's appropriate to bring the counsel together to talk about and try to resolve whether it's, factual issues, legal issues, client issues. Again, being able to have those conversations face to face, I think, is beneficial. If all the parties are in one locale and the mediator's in one locale, I think my preference is still to do it in person. I think this maybe cuts both ways, but I feel like when people are there at the mediator's office for the entire mediation, they're should be committed to the process and focusing on the process as opposed to being at home or in an office and 1 minute you're in the Zoom room and the next minute you're multitasking doing other things. I question whether or not there's the potential for more distractions. On the other hand, for convenience, if people are in multiple cities or especially in smaller cases, I definitely think the economics and the convenience of doing by Zoom is fine, and I've been successful in resolving cases on Zoom where I was here, the case was in another state, and everybody was spread out. Obviously, that just makes more sense than trying to drag everyone together.
Well, Bruce, maybe as a follow-up to what you were just saying, you referenced that maybe different kinds of cases, and you just mentioned, where people are spread out or the size of the case. Is there a type of case that you think makes a difference between in person and Zoom?
Well, I have some clients who just prefer to do it in person. Now, that doesn't mean that every mediator wants to. I've had mediators that I've wanted to do it in person, and they just say, I'm not doing in-person mediations anymore. But again, I think for me, it's not as much the nature of the case, whether it's a construction defect case or just a negligence, case. I've done personal injury cases in the past, and I can't say that whether it's commercial or personal injury dictates that. I think for me, it's more probably where everyone's located and the size of the case. It may be the number of parties, and on the one hand, I think the size of the case, I'd like to do it in person more than via Zoom, but the bigger the case gets, the more parties are involved, then it starts to get more complicated, and the reasons for doing it by Zoom become a little bit more of a weighing in that favor. So there's a little bit of a conflict there, but I don't see that the particular type of case that I'm handling, really drives that preference one way or the other.
I have a question.
Go ahead.
Do you find for the proponents of Zoom mediations, which I see the benefits of both, but I miss the interpersonal interaction, especially in the lobby or at the water cooler, right? I can see opposing counsel and realize that they're a person and we can have a conversation, and if it doesn't settle at the mediation, I can pick up the phone and talk to that person, and it creates a dialogue that during mediation by Zoom, I haven't been able to figure out how to have that. So is there a way to create that? Because normally we're cut into our separate rooms and never see anybody from the other party. So it's this void. There's no reading of the other side because it's all coming through the mediator only. So I wonder if there's some way to
Well, perhaps I
fill
can
that gap.
take a stab at that, because one of the things that I always do is set up, in Zoom you can set up unlimited rooms. And so I always have at least one, what I call extra room set up, just for that purpose. Sometimes it's helpful to have counsel meet, and I'll suggest it at times, but I'll generally let people know too that, hey, there's other rooms available and if you think it would be helpful, because there is a benefit to that.
Right.
And part of it's just the interpersonal side, and then part of it sometimes is technical issues or particular legal issues, and sometimes it's, can we just talk without the clients, right? And so I do think that's valuable, and so, you know, it's not going to be the same accidental oops, you know, we find ourselves walking down the hall to the restroom at the same time. But I think there can still be those opportunities. And I wanted to mention it just so that you all know, because, you know, it's one of the things that I do, and you might keep that in mind as a suggestion, perhaps, in other circumstances. So,
I think one thing that could be done to help, and maybe it's something we're going to talk about later, is how to improve it, is to maybe have. It seems to be in mediations over the last number of years, the trend has gone away from having a general session and just going directly to the separate caucuses.
I don't
know the exact reason why that's happened. Maybe to save time or not have people feel uncomfortable, like years ago when, you know, the lawyers would be talking to the opposing client and almost berating them, you know, in front of the lawyer who's kind of defenseless and feels, you know, wondering whether they say something or not. But I think in Zoom, I think maybe a general session would help, you know, doing that more often, because then you get to see, you know, you get to see not only the lawyer that you probably already have met before and dealt with, but their client that you probably never seen before. You get to see the client. They get to see the opposing counsel. If there's insurance adjuster involved, you get to see the insurance adjuster who you've never seen before, and they get to see you. So I think that might, you know, help alleviate some of the problems with, you know, going directly into your own caucus room and never seeing anybody on the other side. And it's not quite maybe the same as being in person, but at least you get to eyeball who all the people are on the other side and vice versa, and I think that would be helpful.
Yeah, I mean, this is not the same thing, but I mean, I miss the days like where you'd show up at like your office is smaller, but like did a lot of mediations in a JAG or something, and I'd show up there and I'd see like 3 or 4 colleagues and opposing counsel that I knew, and it was just, you know, kind of more like a social thing where you'd see all these people getting donuts. And I remember when I was a new lawyer and went out on my own for the first time and it was one of my first mediations, you know, without as being, you know, newer solo. And Larry Lee had a mediation down the hall, and I went over. I actually got him to give me some advice, you know. And you can't. I mean, that's obviously not going to happen on Zoom now unless you call somebody. But yeah, it was just. I mean, that's just a social thing, but that I kind of missed that a little bit.
So, Steve, do you tend to do general sessions by Zoom?
And let me just ask, hey, Kyle, you're recording this. When participants ask something off the camera, should we repeat the question?
If you'd like to. I mean, I'm watching the levels, and they seem to be coming through pretty well.
Okay, great.
So I think you're okay.
Okay, great.
Thank you for checking.
So your question was, when I'm mediating, do I do general sessions where everybody's together?
Yeah, and particularly by Zoom. Yeah.
Not without asking. You know, I've had so many mediations that back, those many years ago when I started mediating, I got everybody together, that where something blows up and then it's harder to get everybody back together. And so I think in certain circumstances, it can be useful, and maybe I can give you a couple thoughts on when that I see it would be, but I'm still not going to do it without asking. You know, one of the things, Debbie, that you said, I had a client that I didn't how did you say that didn't present
They didn't
well?
present well.
Yeah, and so I don't think you wanted to be ambushed by all of a sudden, the mediator lets everybody in the room. It's like, oh my God, and maybe my client is in a t-shirt and on a messy couch or something like that, and wasn't ready for this to be seen that way. And I've had other lawyers just show up in a freaking t-shirt and so forth as well. And it's like, really? Okay, so there's that aspect of it, but. So for me personally, to answer the question, I'm not going to throw everybody in together without asking first. I think in certain circumstances it can be useful. One of the ones that occurs to me is that if we're dealing with, sometimes I see it in UIM cases, for instance, where you got a first party, claim for injured person in their own insurance company, and it's pre-litigation. There hasn't been depositions. That's not the only circumstance where that's going to be. If we're here early, there have been depositions, it would be helpful for the parties to see each other, get a sense, and have one of the participants be able to speak directly. I think that's useful, and that's one of the reasons I have the extra rooms set up. Sometimes I'll ask, would this be helpful to do that? I think there's other circumstances in which it might be useful as well, but I'm talking too much. So
I'm making notes. Sorry, I wasn't. I read everything.
Debbie, in terms before we leave, the certain types of cases that you see Zoom versus in person. I mean, you're all plaintiffs PI, but do you see a difference in some of the cases that you handle that are going to matter?
I don't think so, because the other thing that we can always do is that sometimes our client, even though it's by Zoom, will come to our office and be with us, if they feel more comfortable doing that. So with that option, I don't see a preference one way or another. Okay.
I'm looking at our
yes.
outline.
We have, so Bruce, and the same question for you. What about representing defendants in the construction or the commercial cases? Do you have a preference one way or another?
No, I as I said earlier, I don't know that whether it's construction defect litigation or just general commercial litigation, or even a personal injury case that sways the difference. I think it's more the other factors of the interpersonal relationships, the size of the case, the convenience for the parties. I think all those factors really weigh more in whether I would, for a particular case, would lean more towards Zoom or in person than the nature of the case itself. I haven't found, mediated many different cases, via Zoom, types of cases via Zoom, and some in person since COVID, and I can't say that I can, say that the nature of the case, that one was better than the other.
Okay, and then what do you think that we can do to improve Zoom mediations now that we've had a couple years to do that?
Do you want to talk?
No, you go ahead.
Really?
Yep. Yeah.
Okay. All right. Well, to me, there's some aspects that have to do with the technical limitations of getting on and off of it for your clients. I think it's going to be beneficial if I would suggest that the lawyers have a practice session with their clients, make sure their clients have the proper technology to be able to get on and to participate. But in terms of we can also maybe open it up and talk in general, in mediation, what's going to help with mediation process itself being more effective, whether it's on or off Zoom, and that's a little bit further down the outline, but I'm also seeing what it is in terms of how much time we're in. So to me it comes down to from the mediator's perspective, if the question is how can attorneys help the mediation process be more effective, it really comes down to preparation of the case, of the client, and the mediator, and to have the case prepared and to be at mediation at the right time, where you've got all the documents, all the disclosures, all the, whether it's PI case bills and records and so forth that have been, put forth and they're out there and everybody has them and can be prepared, and prepare everything in advance as far as the case, and prepare the client for, not just technically can you be prepared to hook up onto Zoom, but to understand what the mediation process is all about, and to have the client be prepared in terms of how things are going to be conducted and proceed, but also in terms of what their expectations for the process are, maybe expectations for the case, and then prepare the mediator in terms of being able to send enough information for the mediator to be prepared to help you. Sound like what's that movie? Help me help you. And I think outreach ahead of time is very helpful. I try when I can to, and I'm pretty good at it, but I don't always get the chance to reach out to counsel prior to the mediation to have sort of an offline discussion, a little bit of a preview, right? And to find out, and sometimes I ask the question, what's not in your mediation statement to me? What should I know about your client? How can I help you? Sometimes, like you said a minute ago, sometimes you want the mediator to put pressure on your client. Or here's what my client's expectations are, or here's an issue with the case where, as attorneys, you're both advocate, right, and counselor at law, and to the extent that you can, sort of drop the mask in a conversation with the mediator as appropriate prior to the mediation, I think it's very helpful to be able to speak candidly in the right kind of case.
That, do you mind if I go real quick?
Sure.
I just thought, well, so this is in general, mediations in general, but one of the things you touched on is communicating in advance. And there's been mediations where I've sent the packet well in advance of the week or whatever deadline it is, and then asked to have a meeting with the mediator. In one case, I remember our client and her husband were from Korea, and her losses were sort of difficult to understand from our culture. And I talked to the mediator in advance, and he made the suggestion that I talk to someone who can teaches like Korean culture. I went to CU and found the person who taught that, and actually disclosed them as an expert, and got a report and had him available. And he explained how this loss was in particular, like she was a pianist and couldn't play the piano anymore, but she didn't really do it for a living, or she didn't, but for her culture to go back and not, that she grew up in a culture where that she learned that very early on, and to not be able to do that was such a huge loss. It'd be a loss for anyone. And the same thing with getting some more information from doctors, or getting demonstratives and things like that, because we get so involved in the case sometimes, and that's one of the reasons why you do focus groups. And so you can essentially use the mediator as a focus group person, tell you what's missing, what questions do you have. And so I think advanced preparation has really helped me in some of these cases, and particularly cases where there were big injuries but maybe hard to understand in some ways.
Yeah, the one thing that in my personal experience, can be done to improve Zoom mediations is to have more, and this is different depending probably on the mediator and on the case and what's going on the other side. But when there are these extraordinarily long delays in hearing, once kind of the mediator's in your room and you either, make an offer, make a demand, and then the mediator in Zoom goes to the other room and there's an hour delay or an hour and a half delay, and you don't hear from anybody as to what's going on. It's just more communications. Because when you're in an in-person mediation, at least what I do is when there's this long delay, I go walk the halls. I'm not listening in to anyone's room, but seeing is the mediator in the room with the, one of the parties, or is the mediator in his own office, waiting to hear back. But at least you can kind of try to figure out what's going on. And sitting in a Zoom room for a huge amount of time, not hearing from anybody, is frustrating for me as the lawyer. And I think it's, my clients have expressed the frustration. It's like, it may be the same thing would happen in person, but at least if someone comes in and says, this is what's going on, someone's waiting to hear from X, Y, or Z, or, I'm waiting for a response, I'm pushing, just some, keeping everyone up to date of what's going on, I think would help, particularly in Zoom when everyone's kind of out in their own little world away from everybody else.
Well, and Zoom does have that little button where
Yes.
you can ask for help, or send a question to Mediator, like, what's going on? Because we encounter that a lot,
Yeah.
where they spend 20 minutes with us and then gone for an hour.
Right. That's one of my suggestions. And I try and be conscious of it. And sometimes I'll just pop in and I go, hello, I'm just here for an interim visit. This is what's going on. I think it's going to be a little bit longer or whatnot. But I would also suggest, taking advantage of the ask for help button. It's shaped like a question mark, not the raise hand button, which is not visible to the mediator when they're not in the room, or to have us set up ahead of time to be able to say, hey, look, I'm going to exchange cell phone numbers with you in case we need to talk, or if someone's not there, or hey, just it's going to be another 20 minutes, or something. I think can be helpful. Sometimes it's helpful to have and I've done this before. Can I talk to you before I come back in the room? Before we talk in front of your client, right? And so there's some tools and some suggestions for that. But you're right. It's frustrating enough for lawyers who are used to the process as opposed to clients who are going insane. What is happening here, right? Yeah.
Steve, you touched on this a little bit earlier, but what, from a practitioner standpoint, from the attorney standpoint, what do you think makes an attorney more effective at mediation? Whether it be, what the attorney does in advance of the mediation, which you touched on a little bit earlier, and how they can present themselves and represent their clients during mediation. It may make one attorney more effective than another.
Well, I already touched on things like preparation and so forth. I think is very important. Managing client expectations. If you're talking about style, right, or certain negotiation techniques, I have a lot of thoughts and do's and don'ts and things like that. But I've seen and Debbie, you started in our preparation meeting. That's one of the questions Debbie started to ask: is are mediations less effective? What's going on? Are you seeing trends and so forth? One of the trends I'm seeing is starting at unreasonably far distances apart based on I don't know what, but all it does is make things take longer. And so that's the opposite of the question you asked, I guess. But so for attorneys to be advocates, right, and advocate hard for your clients, but with a basis, or to be prepared to be reasonable. These sort of unreasonably high starting offers without a basis just make things take longer. Those are some of the things that I see that make it less effective. That if you can take into account the desire to try and get things resolved, I think that's helpful. Other strategies that I've seen in terms of late disclosures or things aren't really prepared, or we're showing up again in the personal injury case with, here's the new treatment and the records and things that the other side's been asking for. That's not helpful. But I feel like I could go down that list and keep talking for a while. So maybe I'll pause.
Well, if you have time, I'd love to hear your do's and don'ts.
But did I answer your question?
You did, and effective. The opposite is again was implicit in the question was what can you do to be effective, but also what should you not do, which would make you ineffective. Which you touched on some, and if you have more, you know.
Well, I'd also like to hear feedback on what makes a mediator more effective, whether it's in Zoom or in-person mediations. So you want to start that one?
Well, definitely the same token as preparation, you know, knowing, yeah, someone who's actually, you know, like read the materials and maybe, and knows the case, I think is super important. I guess the other thing that, I think differentiates one mediator from another is, well, I guess there's two things. One is, I've had mediators that really, I think all they do are just messengers. They don't seem to do much more than just go back and forth between rooms and relay numbers. And then of course the other one is, I mean, obviously we don't like mediators who are super more insurance company friendly and anti-plaintiff. But on the same side, this is really important, is I want it to be a mediator that the insurance company is going to listen to. So like if I pick someone that I think is great because they're really plaintiff friendly and they like my client, they like me, but the insurance company isn't going to respect them or listen to them, then that's not helpful either. So, you know, you kind of want that balance.
So when you say you want someone who's just not just a messenger,
Yeah.
right? Not just passing
I've
numbers back and
Had
forth,
that, yes.
you want feedback,
Yes.
right?
Yeah.
And how heavy-handed, how direct, how circumspect does that depend on the case, the client?
Yeah, I think it definitely depends on the
And
case.
the timing within the mediation?
I have a really sensitive client. I will often let the mediator know in advance or try to, you know, but then this, I don't know. I think honesty and objectivity is usually really good. And even with a sensitive client, I think they need to hear the hard truths too. But it can vary. I mean, I've had cases where I've said, ask the mediator not to beat up on my client too much.
And have you done the opposite as well?
Yeah, I actually have.
Yeah.
I've had conversations, you know, like side conversations where I've talked to mediators about wanting what they think about how my client presents, and also wanting them to give the hard truths.
And I have some of the same kind of, you know, prepared, honest, you know, empathetic, you know, depending, you know, on the case, and creative, you know, and I think that goes to what Debbie's saying. It's just not, you know, necessarily, and every case is different. You know, at some point maybe you get to the point where it's just all about dollars and cents and offers and counter offers, and there's nothing else to be said. But you know, not a one size fits all approach. You know, look at the case, look at the parties, you know, understand, you know, it's just a high conflict, you know, dispute between the parties, and try to be creative. I think, it seemed to be that there was more of a discussion in the past about when the mediator come in and really, you know, again, this is not one size fits all, but, you know, getting each party to talk about or recognize its strengths or its weaknesses, and maybe, you know, being somewhat heavy-handed, and you never know what the mediator is saying in the other room. But I've always told my client, when the mediator comes in, and I never really mind, where they, you know, really push hard to try to, you know, resolve some issues and make people realize, you know, what the risks, rewards are of going forward, that whether the mediator says or not, I tell my client, I said, I believe and I hope that they're doing the same thing in the other room, so that they don't feel like that they're just, you know, picking, you know, because clients sometimes they don't know what's going on in the other room and feel like they're getting picked on. And so, but I think, you know, in a certain case, it's helpful to push a little hard, and sometimes I'll tell the mediator, you know, that, you know, my client, you know, needs to be pushed a little bit here, because maybe their expectation, I don't know, you know, and I generally never ask the client what their bottom line is, because I really don't want to know. But, you know, it's helpful to, you know, be able to, you know, in those circumstances when you know the client's probably being a little unreasonable, to tell the mediator, you know, you need to push maybe a little bit harder than maybe you otherwise would. But, you know, again, just trying to, you know, be creative, which, you know, most mediators are, and not just, you know, mediate every case the exact same way, because every case is different, and the personalities of the clients and the lawyers on the other side are always different.
Well, a couple of other things I think are helpful is if you'd like the mediator's feedback, ask for it, right? And that can be done, you know, right in the mediation, and it's helpful to know when that's appropriate. Well, you know, what would you see on this issue, or how would you see this playing out? As far as that gauge of strengths, weaknesses, especially when we're down to the end, you know, what's this compared with a trial outcome? No one's gonna, if anybody's promising they know what's gonna happen at the trial, of course, that's not real. But you know, inviting feedback, even inviting feedback on during negotiations. I think I like to see that. Sometimes, you know, it seems like certain advocates will be, well, everybody's got different styles, right? And some are more trusting of the mediator's feedback. You know, you don't have to take it, but you can still ask for it. In terms of, you know, especially if the parties are very far apart. You know, what, got any ideas on what we should do next? Do you have any suggestions here? What would, you know, do you have a range that you think we should come back at? Is it time for, you know, a different technique or tool like brackets or things like this? I think that can be helpful to ask. And then, of course, if the parties are going to talk separately, or you're going to talk separately with your client anyway, you don't have to take the feedback. But I think you know, if you're there to try and get the case resolved, you know, help it be positioned correctly so that that can occur. Like some of the, even the pre-mediation negotiations, sometimes I've seen it where there's not been any negotiations so far, and one side is shocked at the opening of the other. And said, if we'd known that's what you were thinking as we were on the phone saying, oh yeah, let's get the case to mediation, yeah, we would have said, no, we don't want to go, or the time isn't right. And so there's some expectation setting that can be done, I think, beforehand that's, I think, necessary and can be very helpful. But go ahead.
Well, I was going to ask you, this is not in our outline, but you know, jury verdict reporter, you can actually have them do a search of certain types of cases, and on some cases we've done that and sent in some of the verdicts. Is that helpful to, you think, the insurance company and to you as a mediator?
I think so.
If the case calls for it, I mean, okay.
I think so. I think it's helpful.
What
and I like to see that, and I like to try and keep track of those things myself, but I don't always have time to do a, you know,
Sure.
I had a case that was you know, the main source of damages in a personal injury case was tinnitus. And, you know, I looked and I couldn't find anything. And I asked the plaintiff's attorney, you're saying how important this is, and they were advocating for very high numbers. And I said, have you seen, you know, something comparable? They said, no, we've looked and there isn't anything out there. And so that was just a recent example, but I love that kind of feedback and information.
What other kind of things can lawyers prepare in advance? How can we prepare in advance that would be helpful, that we haven't already talked about it? We've already talked a lot.
I think if there's any unusual circumstances, like you mentioned, hey, there's going to be this cultural component. That's anything that's out of the ordinary, or perhaps unique as to your case or your client. I think any information that will give some way to objectify that and a basis for what you're talking about would be very helpful in advance. And again, if just the outreach ahead of time.
I think we talked about it earlier. I think having personally, I always, if I can, want to have a call with the mediator before, in advance of the mediation. I mean, in addition to the mediation statement with the, you know, the facts and any legal issues that may be in dispute, and then some evidence. I mean, there's only so much anyone can read in advance, but I think the telephone call, just to talk about the issues, like you said earlier, we've had this conversation, what's not in your mediation statement, or what, is there something that, dynamic I should know about? But I think that conversation, especially if you've never mediated with that mediator before, is really helpful just in advance to start to build some rapport and educate them regarding your side of the case. Maybe it's less important, still important, because every case is different, but when you've mediated with someone before. But I think that's, to me, it's probably one of the most important things to do in advance.
It's kind of hard to follow our outline because we're
I
jumping
know, I
around so
think
much.
we've covered most of it.
We've
Yeah.
covered a
So
lot.
Steve, do you ever get cases where you've done a pre-mediation analysis and you think one side's clearly right and one side's clearly wrong? And what do you do?
Clearly right.
Well, in your opinion, your
Is there
analysis.
such a thing?
Well, much stronger case, much weaker case, let's do it that way.
Sure.
And they come in and they're far apart. How do you handle that? What do you do?
Oh, like today's personal injury mediation from this morning, where it was very low medical bills and high demand and over-treatment of chiropractic and sort of all the things that can go wrong and on one side, and the defense, even though in other cases historically may have been too low, they were about right in the offer. What to do, to try and be candid and honest with both sides, and to talk about the risks and the costs of going forward and the strengths and weaknesses, and I think that's all you can do, because and McQuiston and I talk about this all the time, and the same when Gunning was with us, is I think we're very conscious that people don't want just a number of shufflers, right? And you're hiring someone to try and give you some feedback. And so we do our best to try and be prepared and candid, and hopefully in a way that people can hear, especially if you've got a client who is a person or a business or someone who, doesn't, clients don't do this all the time, right? And the lawyers are used to it. And to them, whether it's a person or a business, it's their case. They're taking it very personally. And I think it's an opportunity that how many cases don't go to trial? 95+% never end up in trial. And so the client never gets a chance to tell someone their story. They can tell their attorney, but they're the advocate. And so to the extent that there's a benefit of someone being heard, I think that's part of one of the benefits of mediation. And so we like to try and understand where the parties are coming from, but also to give our candid and honest feedback in a way that hopefully can be heard and it's effective.
So, I don't know if you call this a strategy or a tool, but things that mediators use at particular points in any mediation, or two that come to mind are brackets, or ultimately a mediator's proposal, and there may be others that you can refer to, but how from a mediator's perspective, how do you decide when to raise those issues, or do you expect those ideas to be suggested by the parties? I mean, how do you those particular approaches and maybe others, how do those end up making it into the mediation process?
Yeah, I'm happy to address that. I certainly want to get everybody's feedback on that as well. Is that to me it's a bit of a gut at this point of, well, how are we doing, and does something need to shift here in terms of parties are just too far apart? How do you break that impasse. And so I'm happy to suggest things. I'm happy to be asked and then suggest things. And I'm happy, and I certainly ask a lot. Sometimes I've seen certain attorneys and advocates sort of jump to something. Oh, well, it's time for brackets. Really? And so sometimes I'll talk people off the ledge of that. Okay, well, this is likely what's going to happen, and we're going to spend an hour arguing over what the brackets are supposed to be. And that may or may not be the case, depending on where things are in the life of the mediation or who's involved. But to explain things, especially for the benefit of clients who probably don't know what that means. Brackets, what are you talking about? And so I'll try and play it by ear because every case is different. But that's a tool that I see sometimes can be used as a crutch, or people jump to it. The same with mediator proposal. Oh, well, why don't you just give us a mediator proposal? Well, really? I mean, the parties are supposed to be making their own decision, and I'm not the arbitrator, and I know that's not what a mediator proposal is. And sometimes there's confusion about what it is, and I think it's something that should only be used sparingly and in the right time.
Because I mean, I guess I've only used it maybe in first party cases, insurance cases, but that kind of always scares me a little. Anybody have? Yeah, but you've seen it be effective at times, or
I've seen it be effective, but I think it's got to be at the right time. I think that parties clearly have to be at an impasse and are not going to move anymore.
okay.
And so now we're trying to break a logjam as opposed to short-circuiting things. And I also think that it should only be done if it's got a chance of success, right? And so when is that likely to have the ability of both sides to potentially buy off on that varies. It's got to be at the right moment in the mediation, and it shouldn't be a crutch. I've seen it quite a bit that there, and particularly in PI cases, where, and I think maybe it's perhaps what I'll call cultural, and maybe that's in-house at particular insurance companies, where I'll get an adjuster and he'll say, well, why don't you just give us a mediator proposal? And I'll ask, well, what they mean by that, and what I've gathered oftentimes, what that means is I need something from a neutral to go to my supervisor and get more money. And it's not the classic mediator proposal, which is, here's my assessment, and they want it to be just to them, right? They want it to be used as a tool to go get more money from their particular superior at the insurance company, as opposed to what I think the classic or the maybe more pure mediator proposal is again, only when there's an impasse and the parties aren't going to move, and set the stage by stating it that no one's going to like this, but here's the number. I'm not saying this is going to be the outcome at trial, or this is the value of the case, although there's a bit of that in there, but this is something that I believe is the correct settlement outcome. And think about it. Don't tell me your answer, but go talk about it and give me your confidential response, and then simultaneously, the other side will only know that you would have accepted it if they did too. So it enables both parties to save face, and kind of cut to the chase and break a logjam. So it shouldn't be overused, and it has to be the right case, the right time for that to occur.
Well, we're almost to the. Well, I guess we are to 5 o'clock. Maybe
we started a little after 4,
know,
so maybe you want to suggest there's.
We can have questions. Yeah, does anyone have any questions or comments?
I apologize in advance if you've already addressed that child driving responsibilities a little late. But I know you're a big fan of the virtual mediations. I'm not sure if you're doing live ones, but have you found that? To me, one of the benefits of a live mediation is, although it could be more, it generally is more costly for the client, but is that the whole war of attrition factor. I've invested a whole day. I got here at 9 in the morning. I've been here in person in this conference room for 7-8 hours. Now I'm here. I've invested all this time personally. Might as well get this done. As opposed to if you're on Zoom, every hour you're logging in when the media, so instead of investing 8 hours, you've invested 2 or 3 hours. You're not there in person. You're not quite as invested in the process. Have you found that to be a factor in perhaps it not being as successful because people aren't necessarily as invested in the process, or not at all?
No.
Okay. That's fine.
And I gave
I'm
a
just
short
curious.
answer because we've sort of
Did you-
addressed that
I'm sorry.
before. Not exactly your question. The war of attrition. Was it last week? It's still went on forever. I started at 9. We finished at 9:15 p.m. and everybody was exhausted, just like they would have been in person. Everybody was logged on the whole time, and we still got it done and got it wrapped up. Thank God.
I remember one we had in person, and it might have been about 9:15 at my office before COVID, and I remember that being kind of a factor. I might have settled on Zoom as well, but I remember we were all sitting there for 12 hours, and we were a few thousand apart, and I remember there was kind of that factor of let's get this done. We've invested so much time here.
I still see that occur, and
Yeah.
what I had said earlier,
And I'm
before
sorry.
you arrived, no, it's okay, was that I haven't seen a case not settle because it was on Zoom.
Okay.
That would have settled otherwise.
Okay.
In my estimation. We're about at an hour. Any other questions or comments? Okay.
Thank you.
Thanks everybody
you.
for
Thank
your
you.
participation and presence and good questions. So, thanks Debbie. Thanks Bruce. Thanks for putting this together.